they're using me.
So listen, guys,
as a
I want
partner.
to talk about the chronology letter, the due diligence receipt, and that whole process. And here's the dealio. One of the things I want you guys to recognize, and we talked about this before, is that problems don't kill transactions. Problems are how you know you have a deal. It's the surprises that kill the transactions, okay? And, you know, Shay can confirm this with you, or when Mr. Celestina pops back in, he can confirm this with you. There's always problems in a commercial transaction. And guys, this goes hand in hand with my story about objections. If somebody's not objecting, what are they also not doing?
Buying.
They're not buying. They're not in a deal, are they? Because these things come up when money's at risk, when things start to happen, okay? So you've got to understand that part and parcel to this whole process is going to be a series of problems, okay? One of the ways that I think you can best handle those problems is, like they used to say in all the old Western movies, head them off at the pass. And what do I mean by that? Well, what I'm talking about is kind of anticipating those problems and getting out in front of them before they even arise. So Ms. Kaplan reminded me, I think yesterday, that I had mentioned I was going to do a chronology letter workshop. So here's the deal. There's a couple of things that I want to talk about. First and foremost, there's always performance issues in a contract. So I want to show you, if I might, a sample contract. Now, this sample contract, first off, guys, I will go on and categorically tell you that it's not my personal favorite. Can anybody tell me why it's not my personal favorite?
Because the FAR.
Because it's a FAR contract. and what is my opinion of the FAR contract?
Shit.
It's pretty much doo-doo. It's an amorphous meatball of problems. So here's the deal. I've redacted this to protect the innocent. Anyhow, this is our traditional, at least they got it on a Florida commercial contract. Ordinarily, we get the purchase and sales agreements, and they say for residential homes and condominiums, but at least they got this on the right document. Now, let me ask you guys the first telling question. What's my main objection with this contract?
Transaction?
No, what's my main problem with the FAR contract? What did we talk about before?
He wants to be one thing solves all the problems, and it just doesn't do it. I mean, it's not solved at all.
It has too many provisions for focus in residential for residential.
It tries to be all things to all people, and consequently ends up being nothing to nobody. And like I told you guys before, one of the challenges is first off, how many of you guys were on the weekly Wednesday webinar when I had Adam Willett on there talking about red flags and contracts? None of you? Great. Thank God I went through all that. Oh, 2 of you. Awesome. Well, the reason I went through that was one of the things that he pointed out was the problem with these contracts is people leave blanks in them. And one of the central arguments that an attorney on the other side is going to have is, if there's a blank, that doesn't constitute what? Yeah, why? What Adam say? It's not a meeting of the minds, because all of those blanks weren't filled in, so it doesn't necessarily constitute a true meeting of the minds. So one of his central arguments was, fill in all the damn blanks. Even if it says, if left blank, it's 5 days. Fill in all the blanks. If you gotta use one, then fill in all the blanks. The other thing we've talked about is why frequently do I actually revert to using these? Or why do I sometimes use these in a transaction? Or why do I sometimes just kind of let it go? Is because it's easier if you've got, like, for example, I know this is going to be shocking and hard to believe, but sometimes you will encounter, for example, attorneys on the other side of a transaction who are, how does one put this delicately, lazy. Okay? So they don't want to do any work for the $250 an hour they're billing, and they'd rather just kind of whip through a standard contract. The problem with this is, and always will be, in commercial there is no standard transaction, is there? I mean, not at all. Not at all. You can have 2 identical buildings on identical lots sitting right next to each other, and they're going to have different transactional aspects. So if you've absolutely positively got to get the deal done, yeah, you got to do it, but you've got to make sure that it sticks. And that's what I want to talk about today. That's what I want to really talk about is how do you put everybody on notice, and on how do you really get everybody singing from the same hymnal when it comes time to do the contract? Okay, so the first thing I did, like I said, was I redacted the names of the parties to protect the innocent or not so innocent in this case. And right there, first thing we see, big blank, big honking blank right in the preamble. Look at line 7 and 8. Okay, if there's no personal property involved in the transaction, what do you do? Cancel it? How about put none right there on the line? None. Why? We've just gotten rid of that potential hotspot. Because, like Adam said, the attorney goes, well, is there any personal property conveying? Well, no, really. Well, are there any stoves, refrigerators, or dishwashers? Well, yes, because it's an 8-unit apartment. Well, they're not listed here. Well, we didn't have a meeting of the minds, so there's not a valid contract. You see how tenuous things can get real quickly? We haven't even gotten into the contract yet. So flying right along here, take a look at our next little ditty here. We got our purchase price. We've got our deposits and all that stuff, who's going to hold it, where it's going to be held, et cetera, et cetera, et cetera. And in this case, at least they put the zeros in. It says 0 additional deposit, 0 other financing, 0, 0, 0. I would even go so far as to put, like, for example, on line 17, you see where it says other? I'd put NA in there, okay? N/A, Y. Not applicable. There's no other money going into the deal. The other thing that I've seen a spate of lately, you like that, spate, is contracts that don't add up, where the cash to close isn't what's actually required. Make damn sure your math works, okay? Cash to close. The other thing I want to talk about, and we'll talk about and catch later, is we'll talk a little bit about financing, okay? So first date we've got to really key on here is the time for acceptance and the time for the contract. So right here, item 3, line 21, time for acceptance, effective date, computation of time, unless this offer is signed by the seller and buyer and executed copy delivered to all parties on or before December 22nd, 2016, this offer will be withdrawn and the buyer's deposit, if any, returned. Okay, so number 1 date we've got to pay attention to, contract date. Right? Now, we talked about this when we talked about contract class. Is it enough to have an offer and have the offer accepted? Is that enough?
No.
What must you have after that? Well, I'm not talking about changes. Well, remember, it's offer, acceptance, and then communication of that acceptance, right? And remember, I was joking with you guys. I said, now every time my phone rings, I go, hey, congratulations, you got a deal. Why? You want to convey that acceptance immediately. Yes? So you've got a deal. They've signed. Okay, now while we're on this, guys, if I write a contract like this, and I scribble some notes in the contract, marginally, or I cross something out and I make some notes, and I present it to Alex, okay, and the seller signs it, do they have to go back through and initial all the changes? No. Why? Because that's the original offer. Get it? They were in the original offer. Now, here's where you get into a sticky wicket. What happens if Alex takes it to his client and his client makes some change and sends it back? Now what do we got? A counter offer. And remember from real estate school, if I make you an offer, even with those handwritten changes, that's construed to be the original offer. If you sign it and accept it, we now have a contract. If you make changes, my original offer is now what? My original offer is now dead, and technically what's happened is Alex's client has become the offeror, making a new offer back to me. In common parlance, we call it a counter offer, right? But in reality, he's making an offer back to me, which constitutes literally a brand new what? Brand new offer, right? It's not a contract yet, because I haven't accepted and we haven't gotten that conveyance, but he's made a new offer back to me. Does that make sense? Okay? So we have offer, acceptance, and then communication of that acceptance. But that's not enough. If the original document could be entirely handwritten. Do I need initials? No. That's the original offer, right? And if the offeror makes the offer and the offeree accepts it, in that form, guess what? We got a contract. Now, if there's any changes made, what do we need? We need initials, and then we need the original offeror, who's now the offeree, to do what? To sign those changes. And in fact, I would even go as far as to have them countersign the contract. Now, one of the things you'll encounter, and I guarantee it's going to happen to somebody here, is the contract's going to go back and forth so many times, it's going to look like some kind of postmodern abstract art project, like somebody wrote on a beautiful newspaper. In that case, what I recommend you do to make sure you have a deal is go back and rewrite the entire contract, incorporating all the changes, right? If not as an exhibit, as a new contract. Does that make some sense? Because especially when the money starts flying, then we get into the he said, she said, they said, we said game. Well, that's not exactly what we had in mind, and I didn't initial that, but I initialed that, and that initial's not mine. Where'd that come from? You with me? So head those. Do a clean one. Head it off at the pass. So first date we've got to really key in on here is our December 22nd. That's the date of our offer, right? And it has to be accepted by, or this offer is unilaterally withdrawn, right? Can we do that? You bet. Now, one of the things that Adam talked about on that call the other day too was they made an offer. The offer expired on Friday. A week later, the broker called up from the other company and said, well, we want your deal. And the buyer said, what deal? Well, you gave us a contract last week. That contract is what? It's withdrawn. Why? It expired a week ago. So one of the key characteristics of a contract or an offer is a lapse of time, right? They didn't accept it by the date that it was essentially set forth in the contract. So guess what? It's dead.
Then?
No, it says it right there.
So
If you don't accept it by the 22nd, that's it. It's done.
But if the seller wants to sell it, why they give it so little time to accept it? Why not do it?
Well, first off, and that's a good question. Why would they drag their feet? Anybody have a theory?
They might have another offer coming up.
Say that again, please.
They might have another offer coming up.
Mr. Maria says that they have another offer.
What happened?
Guess what?
No.
The seller is shopping your offer. That's why, especially when you're dealing with certain companies known to us in the marketplace, you want to make sure that your offer and acceptance period is really short. Because what are they going to do? They're shopping your offer, okay? And they're shopping your offer to cut you out and to put the money in their pocket. I know it sounds nefarious and hard to believe, but people actually do stuff like that. Shocking, I know, but it happens. So, listen, short time for acceptance. Sir?
How many days do you recommend?
How many days? I usually like 2. Because, I mean, think about it, guys, and this is one of the reasons why I keep banging away on you about make sure you become a student of your product type, okay? If you're a student of your product type, and let's just say for the sake of the argument, you're selling 8-unit apartment buildings on East Los Olas Boulevard, or West Los Olas Boulevard, all right? And you own buildings on West Los Olas Boulevard, and you're looking at buying another building on West Los Olas Boulevard. How much time do you really need to make a decision? Hours? Not days, and certainly not a week, right? The other thing is, if you do sign the contract and you do get an acceptance, what do you now have? Well, you have at least a 30-day due diligence, right? So you're tied up, but what can you do during that due diligence? You keep accepting backups as a seller, but if you're the buyer and you went, what was I thinking? What do you get to do as a buyer? Done. I did my inspections, didn't like what I saw, just going to take too much work, right? The problem, and this is the other problem I have with this, is this particular contract. In my contract, it says, if you don't notice us of your objection, then it goes bye-bye. So if you have an exculpatory clause in there that says, for example, you have the right to confirm state and local laws within 10 days, mine says within 10 days, and if you don't object to your findings in writing within 3 days, that particular exculpatory provision is waived. The problem with the FAR-BAR contract is there's no such language. So everything's still fully operative until day 30. What I'm trying to do with my contract is go like this and put them into a chute. You follow me? The other thing I've told you about contracting is the further they get in, the more money they spend, the more likely it is they'll do what? They'll close, right? The more dough they spend, the more money they've got into the deal, the more money they've got at risk, the honester. You like that? The honester they get. All right, next one. In paragraph 3, line 24, the effective date of this contract is the date on which the last one of the buyer or seller has signed or initialed and delivered this offer or the final counteroffer. Is that kind of important? You bet. Guys, you want to make sure you know that date certain, because that's literally the day that the clock starts ticking.
Effective date.
The effective date. Now, here's the question that usually comes up with the effective date. Does the clock start ticking the day of or the day after?
The day off, but the number one is the following day.
Number one's following day. The clock starts today. The count starts tomorrow. Dig it? So tomorrow's day 1. You got 30 days, tomorrow's day 1 of 30. Make sense?
What I always do to confirm is that I send an email to the other party saying let today serve as the execution or effective date of the contract.
Well, we're gonna confirm that also in the chronology letter, which I'm gonna get to in a minute.
Mhm.
But is that a bad habit to get into? Not at all. You guys know that I'm not a big proponent of relying on what?
Email.
Emails, right? I'm not a big proponent of relying on emails because, in case you guys haven't figured it out, sometimes I get on one of my delete fests. All right, you guys, you'll all be sorry. All right, so flying right along here, we've got the date that it starts. We've got the date that it's effective. Now, I'm going to show you how I like to tie that together. Miguel's practice isn't bad either. Send him an email. You might even want to take that a step further and just send him a letter. But we're going to cover that in the chronology letter, okay, in a moment. But the idea is you're putting everybody on notice that what? The clock is ticking, okay? Last part of that paragraph, 28, 29. This is of the essence in this contract. Okay, what does that mean? Well, in everywhere but Florida, it means that the dates as set forth in the agreement and the dates as set forth on the calendar are the dates that things are going to happen. However, in Florida, we have a unique legal concept called mañana. And under the mañana doctrine, if you're just too damn busy, you can do it mañana. Contract be damned, it's mañana. Or if you're a member of the legal community, it's whenever your ski trip is over. Because it doesn't matter that you have a contract with a date in it, it's whenever you get back from your ski trip, which trumps the contract law somehow, individually. But the whole point to my tirade here is every date as set forth in the contract is the date for performance. Okay? Absolute dead certain. In Pennsylvania, and I tell you guys this, over and over again, in New York for the most part, if it says the closing is Friday at 5 p.m., guess where everybody is at 5 p.m.? At the closing. Because if everybody's not there at the closing at 5 p.m., what happens Monday at 9 a.m.? The lawsuits start flying, right? And the deposit is basically transferred the whole 9 yards. Everywhere I've done business except for Florida, that's the case. And unless it's in agreement and in writing, what are we talking about? And we get to that section a little bit later on. Next up, closing date. This particular agreement will close on February 20th, 2017. And it goes on to say, unless specifically extended thereby, and blah, 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 blah. Now, the other one that says, if you look at the last sentence there, buyer may postpone the closing up to 5 days after the insurance underwriting suspension is lifted. What's that dealing with?
What?
Exactly. What?
What was the question?
Buyer may postpone closing up to 5 days after the insurance underwriting suspension is lifted. What is that dealing with?
Most
When
storms.
Maybe
the hurricane's coming and
Hurricanes.
they don't insure.
If you got a hurricane, guess what? You ain't getting insurance,
Underwriting.
right? So they're going to say that you're still able to close this. They call it force majeure, act of God. You can't get insurance, so you can't close. So we wait till 5 days after the insurance
It's available.
is lifted, the ban on insurance is lifted, and you close. It's an automatic extension, okay? Now, guys, again, if you're looking at this on a grand scale, one of the reasons why Like, for example, back after, was it Wilma? The commercial real estate division, just kind of went off the rails. The whole market went off the rails because what couldn't you get? You couldn't get insurance. And if you could get it, instead of it being $1 a square foot, it was like $4 a square foot. Well, what's that do to your NOI real quick? Yeah, slightly. However, there were entrants to our market that were buying stuff left and right because they were either A, self-insured, or B, they had a blanket policy. And some of the companies that had blanket policies, like I was thinking about like TIAA, CREF, and some of the other big institutional companies that actually have insurance were able to get it, but how do they get it? They have a blanket policy. So their policy covers their asset in Miami, it covers their asset in California, it covers their complex in Iowa, and the complex in Indiana, and the one over in Missouri, and the one up in Mississippi. So they've got a policy that's underwritten on a national scale. So what's the national likelihood of a loss? $1 a square foot. And you get some, like Kansas. Okay, you get to some parts of Kansas, the biggest problem you got out there is if you get hit by a tornado, or like South Dakota. What happens in South Dakota? Nothing, In fact, I don't think I've heard of South Dakota on the news. Well, that's just recently. Before that, you never heard of, from late 1800s to about 1999, you never heard of South Dakota on the news.
Yeah.
Anyhow, my point is they spread the risk around and they allocate it according to the portfolio, not to the individual asset. Consequently, the insurance cost is way low. And you got to think about it. From an insurance company's perspective.
They spread the risk.
Yeah. Well, from an insurance company's perspective, if you're insuring one asset in Florida, is that a lot more risky than 100 assets across the country?
Yes.
Yeah, you bet. So that's how they look at it. Next up, we're flying right along here. Closing will take place in Broward. Okay. Third-party financing. Anybody tell me what the immediate problems with that are? The blanks. Within 5 days, if left blank. Guys, in my humble opinion, if a buyer's buying a property, when do you think they ought to be submitting an application for a loan?
Because within 5 days, it is blank.
Yeah, I know. I just said that.
So you have to still put the 5.
Yeah. Fill in the blanks, like Adam said. Because what does that blank constitute? We really didn't have a meeting of the minds, right? Even if it's to put a 5 in there. My personal opinion is, if you sign a contract to buy a building, you should be applying for the mortgage when?
Before the
Tomorrow.
Sure, that way.
Tomorrow. You should have your banker lined up. And guys, one of the things that I've been coaching you to do, remember that little lender list I shot out to all of you? You don't remember that? Franco and I went to the great time and expense of putting it together and then sharing it with everybody on Slack, my top like 10 lenders. What I would do is I would submit the package to each and every one of them. Let's see who kind of pays attention to it. Now, the ones, for example, that I gave Franco were the kind of guys that would do like condos and apartments, not the kind of guys that do medical office. So you remember I told you, become a student of your product type. Know who to go to with this stuff. You might even want to head them off at the pass. How about this radical idea? How about sharing your proposal with a lender or two before you even present it? That way you can put a written expression of interest right in your marketing package, couldn't you? You could say, hey, look, we showed this to Ocean Bank, we showed it to Total Bank, and we showed it to our friends over at Harbor, and all 3 of them liked it and would like to express an interest in lending on this project. I'm not telling the other banks anything. I'm putting it in my marketing package, but I'll share it with them. Next up, one of the problems with this clause, and it's really a chicken bone in my throat, is it says, for example, that the buyer is going to get financing not to exceed 70% of the purchase price. Or blank dollars, okay? What is that? Plain and simple. I said it earlier, it's an exculpatory clause, isn't it? So if they only get 69% LTV, what can they do? Walk away, right?
Or compensate with cash.
Well, if they want to, but theoretically, what are they using this as? An exculpatory clause to get out of it.
A get out clause.
So if they get 69%, not 70, what do they do?
Nope.
Yeah, we're done.
Sorry.
We're done. 5.5% per year.
What do you want them to do then? Because we don't want to leave blanks, but if they put 70, then
Usually what I put in here would be something like at prevailing rates and terms.
If you just write in PREV, normally that's good, right?
Yeah. But prevailing rates and terms. Now, is 70% on an apartment building out of the question?
No,
It's
it's 75.
They could probably go 80% on multifamily, couldn't they? Right now. So that's not a real problem, but guys, be aware of it. Next up, with interest rates not to exceed 5.5%. Has anybody talked to any lenders lately? And what are they lending at?
4.
4, 4.5,
House,
5,
different houses, commercial different.
5.5.
Commercial different houses.
Because the
Yeah.
interest rate increased last couple weeks ago.
Yes.
Right. All over 5%. Okay. Now, guys, here's the question. Miguel says they raised interest rates last week.
Mm-hmm.
Okay.
Point.
Well, hang on. Hold
No,
on.
like 2 weeks ago.
Hold on. They raised interest rates 2 weeks ago. Right. What did they raise 25 basis points 2 weeks ago?
Because the discount rate went up.
Okay. What did they raise 2 weeks ago?
The-
The federal funds rate, right? And they raised it 25 basis points. Let me ask you this most important and telling question. What does that have to do with mortgage lending? It has absolutely nothing to do with mortgage lending, absolutely nothing to do with long-term interest rates. It has everything to do with the money that members of the Federal Reserve are charged to borrow money from the Federal Reserve. So if Chase Manhattan needs some money for short-term capital calls, they call up the Fed as last resort and say, we need $1 billion. The Fed says, 25 basis points overnight. How many people do you know have overnight mortgages? None. Okay. The federal discount rate is what the Fed charges member banks to borrow at what they call the window. And it's the bank of last resort. What's supposed to happen is Chase is supposed to call up their buddies over at Chemical and say, hey, Mario, I need $1 billion. Can you lend me $1 billion till Friday? And they do it between themselves. If they have to call the Fed to borrow money, they've got problems. Because the Fed will lend them money, but after they give them a long and generous cavity search and find out why they needed the money. It's not a good thing. But of all the Federal Reserve Board's open market operations, it's the one that gets the most attention, isn't it? It has absolutely no bearing whatsoever on mortgage interest rates. What does? It has no direct correlation other than the banks are greedy bastards who want your money.
They use it.
So the bank comes to you and goes, well, Miguel, I have to charge you 5% because the federal funds rate just went up 0.25%. And you say, what the hell does that have to do with mortgage rates? And they'll look at you and go, well,
We went up.
it went up, right? Has nothing to do with mortgages. If you want to see what's going to happen in mortgages, you look at the 30-year T-bills, 30-year Treasury bills, and other short-term T-bonds and T-notes. The other thing that the federal open market operations that have the highest impact on mortgage rates are going to be the reserve requirement. What's a reserve requirement? How much cash the bank has to keep on hand for every dollar they put on the street. So, say again?
Fractional reserve.
Yes. So if the Fed says you got to have $1 for every $4 you put on the street, that's the deal. If they come back and say, hey, we've revised our reserve requirements, we have to have $1 for every $5 you put on the street, what happened to the supply of money?
Tighten it.
Huh? 1 for 5?
No.
It went up.
No.
Money's loose, right?
Yeah.
So now the banks want to do what?
Lend.
Lend the money. And remember I told you guys in a previous class that money in a bank is a good thing for you. It's a bad thing for the bank, right?
Sitting there.
Yeah, because the bank's got to do what? They've got to pay interest on it. Even if it's nothing, they still have to pay interest on it and they're not making any money. When they lend it at 5%, what are they doing? They're making money. They're covering their operational costs, they're making a profit, and they're paying you on your CDs. Next, not to exceed blank. Loan fees not to exceed blank. Well, what does that mean? Loan fees not to exceed blank. See me right here in line, what is that?
Interest rate to be charged.
43. Loan fees not to exceed what?
The fees to be charged to the borrower.
Okay. How much are
X.
they? X?
Well,
Guys, again, what did Adam say in that webinar?
No blanks.
No meeting of the minds. What happens if the bank comes back and says, look, We'll give you 70% LTV, no problem. We'll give it to you at 5%, but we want 1 point.
No, but that's better for the seller.
Why?
Because if the bank decides to charge 10% in fees, that's not an excuse from the buyer to get out.
Sure it is.
No, no.
I didn't agree to pay any points.
Of course, there's not many other minds.
See, I didn't agree to pay any points. There's nothing in there about paying any points. I'm out.
You can
Yes,
say-
ma'am?
Why do they have to put what, like the loan breakdown is going to be in the,
What did we just say this is all about?
On a more
It's an
quickly-
exculpatory clause, right? The buyer wants to make sure from the buyer's perspective that the buyer's not getting hosed on their borrowing. So if the terms and conditions of a loan for that particular property are onerous, the buyer can walk away, right?
so it's not only contingent on financing, but the certain terms of the financing?
That's what I'm saying.
Got it.
Not only is it contingent on financing, but it's contingent on those specific terms and conditions, right? What does that mean? If they come back and it's 1%, they can walk away. We didn't agree to any fees. And what did Adam say in that webinar? It's not a true meeting of the mind. So what do? Walk away, right? Not good. And then look at line 45. With additional terms as follow. Hang on a second. I'm channeling the additional terms now. NA, not applicable. NA, right? Or you can do what I do and put in parentheses. This line left blank intentionally. Got it? Check this out. Buyer may within 3 days left if blank. Okay, what do we know about that? More of them. Loan approval in 45 days if left blank. Well, if it's a 30-day due diligence, but if this is left blank, what's the due diligence really? Well, then I can get out because I didn't get my loan yet. Or can I? Exactly. You know how that gets decided? Well, if you leave it blank and the buyer says one thing and the seller says another, where do you go? Court, right? Or arbitration or mediation. But the due diligence said 30, which prevails. Well, the due diligence is over, but I still don't have to close because I didn't get my finance. I can still get out of the contract from the buyer's perspective because I didn't get my financing, right? Seller's sitting there going, ho, 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 whoa, due diligence is over. Buyer says, oh, no, due diligence might be over, but I still have 15 more days because my financing didn't come in.
Okay, so what you suggest is the due diligence and financing contingency be
Coterminous.
same?
Coterminous. Coterminous. In other words, they die at the same time. Well, not necessarily. But if the seller gets a better offer,
Then he's
Then-
ready to close the pot.
yeah. Now, if the seller's got no other offers, what might the seller do?
Let it go.
Exactly.
Yeah. Let it go.
Now,
right?
would you have to note it on the contract, or it would just,
Note what?
like, if there was an extension and you don't meet one of those things?
Well, there's a couple of thoughts there. If you let a sleeping dog lie and they close, what happens? Nothing. However, if you want to make sure, I mean, damn sure that it closes, what would you do? Get an addendum put together, right? We'll talk about that when we get to our chronology letter coming up here in a minute. Okay? But you see what I'm talking about with these problems and these issues? I just crossed that out and put that the buyer will apply for a mortgage and accept a mortgage at prevailing rates and terms. Okay? What's prevailing in the market today? How about this? Title. We're going to have a statutory warranty deed. Okay? What about all those blanks? Property used as. Look at line 71. What's the property being used as? Is it a warehouse? No, not a warehouse. Hospital? Nope. Restaurant? Nope. Multifamily. Well, you see that on that line there? My intent was to buy it and turn it into a drug rehab center for, a halfway house. Well, can't do it. Well, you didn't say it in the contract. Well, it didn't say not to either. See the problem? Again, NA. Here's one of those nasty evidence of title, okay? Now this changes from county to county.
You have two squares, that we put across one on the other.
Yeah.
There.
Yeah.
And then you have the blank after the second one, you still have to put an.
I just put NA. Yeah, NA. All right. Evidence of title, seller within blank days of the effective date. How many days? But 15 days prior to closing. Now, is that the closing that happens in 45 days? Or 30 days from the 45 days? Or 30 days from the 30 days? Get it? See the problem that this engenders? Now, is due diligence 30 days or is it 45? Do they have to close in 6? Or do they extend automatically another 15 because they didn't get their mortgage? And of course, when does everybody make their mortgage application? Yeah, 15, 20 days into the process instead of when?
Next day now.
The next day. We're going to talk about that. We're going to handle that. Title objection? Buyer within 15 days, blah, 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 blah. Buyer delivers proper written notice and seller cures the defects within what?
30 days?
5 days, 2 days, 5 days, 30 days, 45 days,
How long can
180 days?
How long can it take in a commercial? Depends on the problem.
Depends on what it is.
Depends on the problem.
Let's ask Alan when he's back how long it can take to clear a cloud on the title, shall we?
Well, he's not going to be happy for it.
Well, hold on.
He still hasn't closed?
No. What's the problem? One of the sellers died. One of the sellers died intestate, meaning
Probate.
without a will. Okay? One of the sellers died intestate in Puerto Rico. But here's the deal, okay? Here's the deal. The seller died. That's a problem. The seller died intestate. That's another problem. The seller died intestate in Puerto Rico. What it is it's Puerto Rico is essentially it's kind of in flux, let's say,
You don't even know.
between being a state and being in its own sovereign country. And let's just say the record keeping standards aren't the same as we've become accustomed to here. And theoretically, you could go to Puerto Rico and get a death certificate right now. For me, just tell them what blanks I wanted, and I could get a state cert. But here's the problem. Who do you call in Puerto Rico to get that information? And further, what's their incentive to produce it in a timely fashion? Yeah, that may be helpful, but guys, I want you to think about it and think about the extent that some of this stuff can happen. I actually had a transaction. Time was of the essence. The guy signed a contract, and I was peripherally involved in it. Went home to visit his family for the holidays. Did not show up in the United States. Did not come back for a year. No habla? He went home for the holidays. Did not come back to the United States for a year. Okay? The broker who I was working for at the time decided that constituted a default, so he gave all of the deposit to the seller. Tore up the contract, gave the deposit money to the seller. After like 6 or 8 months of this guy not communicating, not coming back, not doing anything. The guy comes back to the United States like a year and 15 days later, walks into the office and says, "I'm back, where's my money?" And the broker sat there and went, right? So the house is sold, the new owners are living in the house, the guy's money's gone, the guy's back in the United States and wants his money back because he doesn't have a house. The broker's sitting there going, and he decides to file a complaint with the Florida Real Estate Commission. Mario's sitting there shaking his head going, no.
Good luck with that.
Well, this thing went to court. Now, who decides what the contract means? The judge. So this case goes to court. The guy comes in with his attorney. I mean, this whole case lasted, the whole trial lasted 15 seconds.
Wow.
No.
I honest to God, it lasted 15 seconds. The guy walks in, they read the litigation and all that stuff, and the guy gets up and says, "Well, Your Honor, in all fairness, my client was broker, blah, blah, blah. He had the money, he was holding in good faith, and yakety schmackety," and he's going on and on and on about how he did this and this and this and this, even though he violated every escrow disbursement procedure known to mankind. Yeah, he completely just threw that all out the window, and the attorney for the buyer, whose money is, the guy who's looking for money, gets up and says, "Well, Your Honor, yes, my client was out of the country for a year. Yes, my client did not communicate with the broker because my client went home to Yemen for the holidays, and they had a political uprising, and the government was overthrown, and consequently, all of the phones, everything, were shut down for a year. He couldn't even get out of the country. Couldn't make calls, couldn't get out of the country, couldn't receive calls. There was no transmissions of anything into or out of the country, no emails, no nothing. My client arrived back in the United States and wanted his money back because he couldn't effect the sale. The house is sold, blah, 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 blah." The judge goes, "Guess what? Give him his money back." That was the whole trial. Give him his money back. To think about that. Again, who determines? The judge does, okay? The broker, incidentally, had to pay back all the money, and then had to pay back all the costs, then had to pay for the 63-hour broker re-education course, and I think $1,000 worth of fees, a fine, et cetera, et cetera, et cetera. And then, no. What happens is the broker says that he's got conflicting demands, pays the money into an escrow account or a bill of interpleader, and sends all of that off to Freck, who then makes a determination and ruling as to what to do with the money. And I will tell you that in 99.9% of the cases, they give the money back to the buyer.
And because again, EDO.
Yep, they get an escrow disbursement order, done. Got it? But who determines that? Freck or the judge? Yeah, because that, guys, guess what? That's not your money. And I mean, literally, I had an instance, for example, where, and this is a while ago, I was coming back from a transaction. I had like a $3,500 cash deposit, literally, in my right pocket. I have a screaming baby in the back seat of my car, and like $4 in my pocket, and I'm running out of gas. And I'm going, okay, I got $4, I got 500, I got $4, I got a screaming kid, $4. Well, nobody will know if I take a 20 out of that. Put $20 and get back to the house, and put 20 back in. But guess what that is? That's conversion. All right, it's not my property, right? Well, in Italy, it's like, in Italy, you take the money, you put a Post-it note in, you pay it back later on. I owe you. Right? Yeah. So I put the $4 worth of gas in, got home, got rid of the screaming baby, and deposited the money the following business day. Okay? The point is, it's not your property, it's not your money, it's conversion. Okay? Who determines this stuff? The courts do. I know that's a little bit of a rambling digression there, but understand it speaks to what we got going on here. What do you do with it? Deposit.
That's why never have an escrow account in your name.
I tried to use my maiden name. They didn't buy that.
Yeah.
My aliases. No, just get next up. Due diligence. 15 days. Uh-oh. So they have 15 days to inspect the property for all these different things, right? Or do they? When's the due diligence over? Well, is it?
45.
45? Well, technically, according to this, the due diligence period, their ability to get out of the contract due to physical or other issues related to the real estate is over in 15 days. But literally, they have the property tied up and in limbo for how long? 45, based on that open-ended financing contingency. Okay, guys, you got to know something. Time never helps a real estate transaction. And why do I say that? If there's an extended closing, any bad news impacts the seller adversely. Any good news, the buyer gets a bonus. And what do I mean by that? Well, well, they could get a discount, but how about this? How about the property is upzoned? It goes from like 3 units an acre to 25 units an acre. Does that make it worth more? A lot more. But the buyer just got that for free, didn't they? The seller can't come back and go, yeah, I've decided to change my mind. It was rezoned, et cetera, et cetera, et cetera. I want more money. Once they're under agreement, aren't they? If it's down zoned, the buyer can come back and go, oh, look, we bought it for this purpose. We can't use it for this purpose anymore. And according to this, we get our money back. So the longer this thing is open, the less likely it is to, who's blinging? So how long are we tied up? Well, theoretically, we're tied up for 45 days, right? Or 15, or who knows, whatever. I mean, at this point, whatever.
So all those days have to be consistent.
Ah, splendid. Operations. Now this is one. The property will be operated in its current condition, current use. Okay, great. Only with the buyer's consent. So they're saying that if you make any changes, you have to get the buyer's permission to do it. Not necessarily unreasonable, because sometimes you'll see what's called the brother-in-law clause, where they put the brother-in-law in an apartment for like $6 a year for the next 400 years, and it's a valid lease. Okay, but it's a problem, isn't it? What just happened to your cash flow? Yeah, a lot. Closing procedures, blah, 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 blah. Taxes and prorations, we know all about that. FERPTA, we know about. Escrow agent. Curative periods. Take a look at that. 11. Line 211. Non-complying party will have blank days after delivery of the notice to comply. Notice and cure shall not apply to failure to close. Any?
It's just like crap out.
It's okay. Well, when do we have to comply?
Silly.
Do you see why Adam said there's issues here, right? There's issues here. And the problem with it is, in order to make this an operative contract, you have to make so many changes and slap on addenda. Guys, understand that every time you hang a piece of addenda on the back of this, what do you have to do to the contract? You got to go back and get rid of any conflicting clauses or provisions in the contract, right? I got news for you. Attorneys don't get this stuff right. How are you going to do it?
Well, you can say that on
Well,
the addendum.
hold
If
it.
there's any
Yeah, you
conflict
could.
between the
Or-
contract and the addendum will supersede any contract.
Right? And then who decides that?
What do you mean, who decides?
Who decides that? The judge.
There's an addendum signed that says
It doesn't matter. And if somebody takes it to court, if somebody takes it to court and says, "Well, you know what? Listen, how many of you seen any document that says by signing this document you've agreed that you've read and fully understand this agreement and acknowledge that you've been provided a copy of it?" How many times do you think any of those have ever been overturned? All the time.
What happens if you go to the special notes in the contract and you say, addendum number 1 will supersede
You could.
the terms in sentence number 211?
You could, but again, you're going to have an addendum that's addendumizing the addendum.
No, but
Of the contract.
The idea is that you put it.
Oh,
in
I
the
understand what the
agreement,
idea is.
And you basically pinpoint it, right?
What you need to do to make it operable is get rid of any conflicting provisions, right? Strike them. And Miguel was on the right track. What you add is language that says that this addendum is in fact prevailing, and that unless otherwise expressed, all of the other terms and conditions remain in full force and effect. Okay? The challenge with it is if you don't do that, what do you have?
A conflict.
You've got conflicts. And guys, that's what I'm saying. You want to try and head this stuff off at the pass to the extent you can. And I don't want to spend a whole huge amount of time going over the contract because we've already done this a couple of times. But I think you're seeing what I'm talking about here with regards to the FARBAR contract and the problems with those little blanks. Here's my favorite, 246, radon gas. Radon gas is an actually occurring gas that poses a health risk over time. I will give anybody here a crispy $100 bill if they can find me a single documented case of anybody dying as a result of radon gas, ever. Guys, have you ever heard of the book Freakonomics? Okay, you read it?
Yes.
Okay, well, like this morning I was watching TV. I'll give you a primary example. I was watching TV this morning, and two-year-old twins were playing in their bedroom and pulled a dresser over on. Did you guys see that?
I saw
Yeah.
that last night.
Right? Yeah, the kid pushed it off. Okay, so
Amazing.
yeah. So here's the deal. Now all of a sudden, watch this. Now all of a sudden, have you guys heard about like the TV straps to strap the TV to the wall?
Yeah.
And strapping furniture to the wall? Okay, here's what's going to happen next. There's going to be legislation requiring furniture to be strapped to the walls to protect kids. Okay, now do not take this the wrong way. How many kids die every year from dressers falling on them? Huh? Like 4. Okay. Now I want you to think about this, guys. Don't take this the wrong way, but from a purely economic and social standard, the billions of dollars that will be spent to eradicate the deaths of 4 children, is it economically worth it?
No.
Economically worth it?
Because nothing changed.
No. Hold it.
This is exactly
Shay,
why-
you're missing. No. You guys are
hold on.
missing.
It's exactly the same concept about Toyota or the
No,
airbag.
listen.
That's
You're
exactly
missing.
what they do.
You're misunderstanding what I'm saying. You're not getting what I'm
No,
saying.
I'm getting exactly what you're saying.
Any loss of a child is tragic, right?
Of any human being.
But if never mind. I can't talk to you guys. If you could spend $1 billion, for example, on vaccinations, how many kids would you save? Or if you spent $1 billion on food in sub-Saharan Africa, how many kids could you save? But that doesn't get the press, does it? Well, my whole point in this conversation
Doesn't change anything.
is the stuff that's important doesn't make it. The stuff that's not important or is complete, like child safety seats. You read it in the book. A kid getting killed in a car accident is massively tragic, okay? Don't get me wrong. Kids should be in child safety seats. But you shouldn't have to spend $2 billion to get it done. It should be done. It should not even be a thought process.
Oh my God.
Anyhow, let's flying right along here.
Moving along.
Flying right along here. How about this? This is the one that really causes me, I believe the correct word is angina. Subject, angina is chest pains, usually correlated with your heart. Additional terms, subject to appraisal at the sales price, okay? Copy of all leases and financial info related to the property. Okay, we've copied them because we meet the criteria here. Due diligence will start once buyer receives all leases and financial information related to the property. Ha ha. That's the chicken bone in my throat. Okay? What are they basically saying?
Who decides?
What do you mean?
When's
The seller has to provide all the documentation.
well, hold on one damn minute. When does due diligence start?
The date of the contract?
Well, the date of contract?
Well, but in reality, it
Well,
shouldn't.
when you hold it, or when you hand them this pile,
When you hand it.
or when you hand them this pile and they've looked at it.
Which one is it?
That's what I'm asking you.
It says right here, once buyer receive all leases and financial information related to the
I
property.
agree.
That's what they expect. That's my opinion.
Now, I understand all your, not complaints, but all your reasoning for all of this, but it also depends on, what?
Observations.
There you go, observation. But it also depends on what side are you on. Now, in this case, Mr. Celestina is on the seller side,
Right?
so he doesn't want that clause. But
Uh-huh.
if I'm the buyer, I want it in.
Uh-huh.
Uh-huh.
But that's not my point.
What do you
What's your
mean?
point?
That's not my point. My point is, do we have a contract?
No.
Why not?
No.
Why not?
Well, no,
There's
because
a
it's
lot
not
of-
signed by the seller yet.
Wait, well, not only is it not signed by the seller, but we don't have any kind of understanding as to when due diligence starts, do we?
Yeah, not
Correct.
Like
So-
correct
Does
dates.
it start the day the contract is signed,
No.
as set forth in the paragraph above?
It says
No.
right there when it-
Does
when
it start? Well, does this prevail?
Of course it will,
Well, why?
because this supersedes the contract.
It does?
Yes.
Well, Your Honor.
I've been no, the reason I say it does
wait to-
supersede
I
because.
can't wait to hear this.
Judge, yeah, coming in.
Okay, based on the legal proceedings I have.
Just now?
Previously-
Just now?
No, the one that I won, this is what the attorney told me, that anything written on the contract will prevail against anything that it's already,
In the other part.
yeah, like, you know, I know you don't like the word standard. So, but anything that it's already like standard on the contract, if you write something there, it will supersede the.
It's supposed to.
Additional terms with.
No.
Well,
This is on my previous experience.
well, if,
Mrs.
and
That's
listen,
true.
The favorita del jefe should speak since she has legal privilege, legal experience.
hold on a second, hold on a second, hold on a second, I'm looking. You know what, first off, I don't see anything in here that says
That this will supersede the other.
that it supersedes the provisions set forth in the contract above. I don't see that anywhere. On top of that, what if I'm the seller's attorney? I go, hold on one damn minute. No. You got 15 days. Your clock starts now, okay? Let me tell you why we're having this little meeting. Because of this. Because here's what I want you guys, of course I'm recording it. I've got all of the silliness documented for posterity's sake. Oh, you guys have no idea. This thing's got problems. Yes?
Yeah.
I'm not, and understand, you're gonna have to deal with it. My point is,
He's the seller, right?
yeah, he's representing the seller. Okay, we got another contract, better than this one that we're
So
under.
what do? You just counter on the new.
Well, that's
doc-
typically,
on your document?
that's typically what I would do. And if you find out that the parties you're dealing with are not, let's say, the most astute, then just let it rip. You know?
Meaning, use this one.
Yeah, sanitize it and let it rip. Now remember, there's two schools of thought here that if you start making changes and writing addendum, you know, you're practicing law.
Right.
Okay? However, if it's something that's purely hypothetical and for illustrative purposes only, and council decides to incorporate it, or the owner decides to incorporate it, or the buyer decides to incorporate it, what is it?
The decision.
It's their decision, isn't it?
Buyers or sellers instructions.
Yep, absolutely. So remember, I'm not giving you legal or accounting advice, but Adam said if you get a letter from the buyer or seller says, I told him to do it, do it. Got it?
So with this kind of contract, then, even though it's like,
Here's what I would do. Right? Here's what I would do. And here's a sample addendum that I would hang on the back of this and shoot it over. Now, one of the things that I've done over the years in an attempt to kind of head this mess off at the pass is I will send during due diligence, or right after I list the property, a copy of my proprietary purchase and sales agreement to the seller's counsel. Why?
Whether,
Talking about like their lawyers?
iron out whatever he doesn't like.
Huh?
talking about like their lawyer?
Yeah. I send a copy. Absolutely. He can go through, or she can go through, look at the contract, add any exculpatory clauses they want to see, make any changes, right? And then that's the document that we can use moving forward. Now, let me tell you something. You'll get conversations going with buyers on the other side saying, well, we're not going to use that. We're going to use the FAR bar, contract. And I would say, well, I understand why you might say that, but if you want to buy my seller's property, we're going to use the contract that the seller's attorney has reviewed and approved. Here it is. Get it? And if you're just mired in that struggle that they cannot get their arms around the notion of using that agreement, then you're going to have to deal with the FAR bar. But you're going to have to make sure all the blanks are filled in. You're going to have to read over it about 16 times and make sure everybody knows what's going on, and make damn sure you follow the processes that I'm about to talk about, okay? Now, this is why I had this meeting. This is why Shannon reminded me that we had to have this meeting today, so thank her for this.
Thank you, Shane.
But here's the deal. One of the first things that I do, and you guys have heard me say that with almost no exception, is I start gathering the due diligence material while we're doing the proposal. Why?
Because we want
So
to be
you
ready.
can avoid that.
You're already there, right? I mean, are we not going to get the leases? Well, how are we underwriting the property if we don't have the leases? Are we going to have the income and expense statements? You bet, because guess what? How do we do our proposal? We're going to have pictures. You bet. Absolutely. We're even going to have a survey if you can get your client to send it to you, right? Plug in, we need another power. So again, what are we doing? We're going to gather all that stuff. We're going to gather all that stuff when we're doing the proposal, right? Okay, so guys, we're going to gather all that data. We're going to gather all that information to do the proposal, right? We've got it. What are we going to do? Copy it, hang on to it, right? You're making your due diligence package now, right now, when you're doing the proposal. That way, when you've got it on the market, you don't have to scramble and try to put it together, do you? Make sense? Like, for example, right now, technically, if I'm not mistaken, we actually put Coral Springs under contract before we had it listed, okay? That, right there, for the most part, is the due diligence package for the Green Turtle Plaza. Right there are all the leases. There are the income and expenses. There's everything right there, okay? So what do? Take a look. I just ordered a whole box of them. Sir?
You have a checklist of all of these.
Oh yeah, and you do too. I gave it to you. It's in the Dropbox. Also, this is in the Dropbox. First thing I'm going to do. And Sharif picked it up because he saw it went in over the holidays. What I did was I wrote, for your benefit, a new due diligence receipt right here. It's in the Dropbox. And literally what I would recommend you do, and this is my business practice, is let's say my buddy Miguel has put a contract together and it's been accepted on Green Turtle Plaza.
So have the agent and the buyer sign on it.
Absolutely, or at least the agent. So what I'm going to do is I'm going to go, hey Miguel, here you go, and by the way, sign this. Now what did we just take care of?
That they
The effective
received
date
and they.
Remember that?
The effective date on the diligence or the contract.
Yeah, remember that highlighted area on the contract that I had just shown you, where the contract doesn't begin until all of the financial information is delivered? Well, guess what this says? You got it. It's a receipt for the delivery of that material. You got it.
The clock stopped ticking.
The clock is now ticking. So what's our boy have to say about that? When he comes back and says, well, we didn't get the due diligence. Oh, no.
sure did.
Please, here it is. You signed this, didn't you? You're in receipt of it. There it is. Got it?
So when we give the due diligence package to the buyer, we do it physically.
Here, Alex.
Just saying physically, not through email then.
Sign here.
Well, Alex, it doesn't matter as long as you give it what it matters is that receipt to make sure that we all have verification that they have.
No, hold it. It
That's what I'm saying, because
does
if you
matter.
send, like,
If
email,
you
they
can
might not sign
hand
it.
him the due diligence package physically and get him to sign that letter physically, what do you think you should do?
Sign it.
That's right. Get it there, put it in his hand, have him sign it. What do you now have? Evidence. The clock is ticking, right? Now, that doesn't mean you're going to eliminate the problem, okay? I want to be clear on that. What that does tell you, however, is you've now basically put them on notice, okay? Now, I had a case where I literally, and I think Shay might have met the guy. No, I know she met the guy. I was doing a deal with him, Alan Krinsman, remember him? I was doing a deal with Alan. I handed him the due diligence pile, had him sign the receipt, and a week later he says the due diligence didn't start because he's still looking for this, and this, right? And I sent him back an email and said, oh, hold on one damn minute. Your item 3 is my item D. Your item 1 is my item F. It's all there. And it's like one of those things you did when you were a kid where you match the letter and the number. Like, there it is. You've got it all. I said, and literally I said to him, did you ever actually look at the packet? And guess what the answer was? No, it's there. You've had it for 2 weeks. The clock is ticking, okay? So by handing them the due diligence receipt and handing them the due diligence material, the clock is now ticking. And we've made that contract pretty much fully operative at this point, haven't we? So now we've eliminated their exculpatory clause. Now, as far as appraising at the purchase price or any of those other things, it depends, like Miguel said earlier, on whose side are you on? Whose hat are you wearing? Are you the buy side or are you the sell side? We talked about that in a prior class. So here's the letter. Basically, the letter just says, oh, and fill in the blanks. Take out the lines, fill in the blanks. Purchase the property located at, dear so-and-so, this letter shall serve as receipt confirmation of the delivery of the due diligence material set forth in the purchase and sales agreement by and between, blank as seller, and blank as buyer, dated, blah, 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 and regarding the property located at, more fully described as, and bearing a folio number of, voila. What have we now done? We've identified the certain contract, the property, and the party. And then sign here, you got it. Make sense? So guess what we just did? That one's gone. Nope, clock is ticking. And I'm telling you right now, guys, make it a habit. When you're putting together your proposal, gather all that information. That's why I went to the length of putting that first appointment checklist together. Hey, listen, we're going to need copies of the leases. Can you get me those? We're going to need copies of any utility bills. We're going to need a copy of your income and expense statement. We're going to need copies of this. The other thing you really need to focus on is when they give you this laundry list of stuff they want for due diligence, one of the things that I'll usually throw in there is which shall not cause the seller to incur any cost in the production thereof and are in the seller's possession, period. So let's just say that it says that the seller is going to provide him his prior survey. The seller can't find it. So what's the seller going to do? Run out and get a survey, pay for it, and then give it to the buyer? No. Seller says, I can't find it. I don't have it, can't find it, can't produce it. Guess what? It's not in my possession, right? Like we've got something, well, how about your prior environmental inspection? I bought the building in 1989. What's the likelihood of me actually having that? Or how about your termite inspection from 1978? Yeah, right. Think that's likely to happen? Not hard. Well, yeah, if you had it, it probably doesn't mean anything today anyhow, right? And they can. And you say, not in our possession, going to cost us money to produce it. Not providing it, right? What, pretty much. And if they accept it, right? If they accept it, that's it. Here it is. But my point to this conversation is gather the stuff now, early on, because the last thing you want to be doing is when you're under the pressure of a deal, scrambling to try and get it. We're going through that right now. Yes, with Alex and Shay on a deal. We're getting all of our due diligence piecemeal because for some reason or another, the attorney for the seller has decided that's the way he's going to dole it out. No idea why. No idea why the seller's attorney thinks he should be the one providing it. So do the math on this one. The request is made to the seller. The seller provides it to his attorney. His attorney dutifully sits on it for 3 days, then provides half of what's asked for each and every time he's asked for something. Then you have to go back and ask for more, which the seller then has to give to the attorney, who sits on it for 3 more days, and then gives you the other half, while he charges $250 an hour. I'm gonna have to cut all this attorney bashing stuff out.
Just get your bar exam. Be you the attorney so we can.
Well, you know what?
Adam Bonner-Romer's attorney.
I actually told Adam Ouellette, who he and I were partners for years, that I was going to go. I was going to go to law school and get my law degree and get admitted to the bar. That way, I could kill my own deals and save all that time and money. I could just kill them myself and eliminate the middleman and eliminate the middleman. Just kill my own deals and charge for it. Guys, here's a chronology letter. Now, this chronology letter does not reflect the actual contract we just looked at.
This is not the same letter that we just saw.
No, this is different. The first letter I just showed you was a receipt for the due diligence material, right? And confirmation of the due diligence material. This is a chronology letter. Now, the purpose of this chronology letter, ladies and gentlemen, is to put all parties to the contract on notice that we're doing what? Who what? No, we're following up and making sure that everything that's to be performed in the contract and who it's to be performed by is happening. Because here's, I know,
a summarized contract.
This is basically a summary of the dates for performance.
Of the contract.
Right. Because here, I know it's shocking and hard to believe, but here's what happens in a transaction. And I think I told you this before. You turn it over to a title company or an attorney. When do they look at it?
The day before closing.
Yeah, the day before closing, and then there's a collective. We've got to get all this done, and we've got 1 day to do it.
Yeah, I do that also on an email, but this is way better. That way you have it.
Well, you can even email it too, but what I'm saying is, guys, do not rely on email. Emails get lost. Emails get deleted. Somebody, oh, I never saw it. You know, it could get bounced. Who knows? The other thing is, I got news for you. How many times do you think I've ever had to reboot? How many times has it gotten a virus? How many times is the internet not connected to it? Get it? Worst case scenario, what's the absolute worst thing that could happen here? Fire. What's the likelihood of it burning to the ground while I'm gone? Now, while we're on the records, copies you keep, originals go where? In the office. All right, got it. So check it out. What's the first date on our chronology letter? Yeah, contract date. When was the contract put together? Right? And then the effective date. What did we say the effective date? Well, the effective date was the date that the last of the parties either signed or initialed, which was also the same day that we did what? We delivered the due diligence material. That's my personal practice. When we've got the last, I mean, literally, when the last party signs the contract, I usually have that together and go, and here's your due diligence material, sign here. Everything's there, right? I just go, hey, you signed the contract, here's your due diligence material, the clock is ticking. Well, your sellers had probably a month or two to cooperate because you keep asking them for the materials, keep asking, even if you get it in little pieces. You know, put it in the file, keep it together, right? Yeah, well, the effective date's today, the deposit's due Friday. Or the deposit could have been tendered with the contract, right? But that doesn't mean the deposit's not due by that. In fact, what will happen is if the deposit was tendered with the contract, although it has that 3-day provision, I'll put in received, tendered with contract. You follow me? So that we all already know that we got it. The other thing, and this is why I hated that FAR-BAR contract. Yeah, photocopy it, put it with the contract, and bring the check to the office and turn it in immediately.
But you don't establish in there that
you could put tendered by check number, blah 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 blah.
Because technically, it's not a receipt until you get the money.
Right, but you could still put tendered in a form of a check, yada yada yada.
Right. That's my question.
But now, guys, again, what have we done? We've established the timeline. We put everybody on notice. Yes. Mortgage application. Notice in here, the mortgage application was 7 days after the effective date, not 45 days. In my contract, it basically says 3 days. Sign the contract, effective date, 3 days later you apply for a mortgage. How do we confirm that? Well, in my agreement, it says you're going to provide me written confirmation from a lender that you've applied for the mortgage. And guess where that goes? File. I don't care if you apply 17 of them. I want to see evidence that you've applied for at least one mortgage.
Okay, I get that. Shana asked the same question. What if you, like, I have a buyer right now who's actually going through the loan process before shopping for the property?
If they're approved, that's fine. But that does not, no, it doesn't meet the requirements.
What will be the, sorry.
A loan
No, hold it.
application needs to be actually for that specific.
For that specific property. Exactly.
So meaning submitting documentation to
Yep.
the bank. Okay,
Listen, just 'cause you're just-
I, Miguel Maria, am pre-approved. Now this is the asset that I'm.
What are they lending on?
That's what I'm saying.
They're not lending on Miguel, they're
No,
lending on the building,
I
right?
understand, but
So you're pre-approved, big deal. Are you pre-approved for that building? No, they pre-approve you based on credit.
Oh, that's
Credit and global income. They say, okay, listen, you make $300,000 a year and you got excellent credit, you can buy $1 million building. Okay, great. Can I buy that $1 million building?
now
No.
we'll get the building.
Yeah. Can I buy that $1 million building right there? No.
So,
You got to
to-
apply.
To provide information about the asset will constitute in an
Applying
application within
for
the 3 days or 4 days
applying
or
for
whatever.
a mortgage constitutes applying for a mortgage. That's what it counts. That's what constitutes it. Yeah, I don't care if you're accepted or not. I want to see that you're doing the things that you're supposed to be. I don't care if you apply to 17 of them. What do I want to see? That you're actually proceeding with the agreement as set forth in the agreement. Yes? And remember, they're underwriting the property in this case, not you.
Well, the right both. They want to see you good. What's it called? The
Yeah.
good.
Back in the happy days, when they were putting wheelbarrows full of money out the front door, okay, if you could fog a mirror, they'd lend you money.
That was back in 04.
And it's going to happen again. It's happened before. In fact, back when you were a toddler and I got started in this business, they were doing the same thing, weren't they?
In the 80s?
Yeah.
I thought the 80s was a recession.
No. There were periods of
Or
time
the
in
90s, was it?
80s and 90s, there were recessions in both of them. But there were also times where the banks were putting money in wheelbarrows and carting it out the front door. There was even a time in the 80s where they would give you 125% of your stabilized value on a property.
135?
125%. So here's the point. All I'm trying to do is make sure that you as a buyer are doing what you're supposed to be doing. I don't care if you make 17 applications. What do I want? One. I want to know you're doing it, okay? Mortgage commitment. I'm not waiting 45 days like it says in that other agreement. I want to know that you've got a commitment within 30 days. I want it coterminous with your due diligence. Because like I said earlier, nothing good can happen if what? Time frame.
So
If that time.
right there is the same deadline for the due diligence, financial due diligence.
Yep.
and
Physical.
us-
Well,
us-
remember, I'm separating
you
everything
separated
out.
Everything.
So you've got like 15 or 30 days to do your physical inspection. Now, I'm going to ask you a technical question, Ms. Kaplan. How long did your physical inspection take the other day? Did it take 30 days? Did it take 30 days?
Including report?
Including the report. Okay, but was it under 30 days? Well under 30 days. Could you conceivably get an inspection and the report the same day? Yes. If you order the inspection, you'll get the inspection. What do most of these clowns do? Wait till they get a mortgage approval and then apply for the inspection and then order their environmental. That's not what the agreement said. The agreement says, and I've had this argument countless thousands of times, you call them up and they'll go, well, we need a 2-week extension. Why? We didn't get our environmental back. When did you order it? Yesterday. Why? Well, we didn't have mortgage approval yet. It doesn't say in the contract that you wait to get mortgage approval before you perform your inspection. It says you have 30 days to complete your inspection and reject the property or accept it. We're not extending for another 2 weeks because you didn't order it in a timely fashion. Oh yeah, but guess what? If you're buying $1 million building, you're going to have some dough in the building in the process, aren't you? Listen, I've walked away from like $40,000 already on a building that I was buying because I got into it and I went, oh hell no. I need X dollars to make this thing fly because there's problems with the roof, there's problems with this, there's problems with that. And the seller says, well, I'm not giving you any credits. Okay, I'm out, terminated the contract and lost all the money I had in it.
Well, look at it this way. If he would have lost more, he would have lost more if he would have gone.
Well,
through.
yeah, hold on. Let me see if I understand this. I can either lose my $40,000 that I spent or buy $400,000 worth of problem. I'll take the $40,000 hit. Now, fascinating fact, don't.
What's up with the finger? Straight or?
Because, what do you think happened after the guy refused to give me my concessions? Hurricane Wilma hit, tore the roof off the building, and he called me up and asked me if I still wanted to buy it. No! Huh? No! Guess what? Tough luck, son. Huh?
50%
50%. But here's my point. Is it better to take the $40,000 hit or buy the $400,000 problem? You follow me?
Put those
Cry either
$40,000
way.
What's that?
You cry either way.
Yeah.
And just walk away.
Yeah, but it's a lot less crying, trust me. So here's the point. You find out you've got the opportunity to A, renegotiate, B, walk away. You can't be in commercial real estate on any meaningful level and not spend money. It costs money, period. And when you have these yahoos that think they're going to buy a commercial property with no money down, they're smoking crack. No, I'm sorry to disabuse you of that notion. Okay, we've got review of title, additional deposits, physical inspections, financial due diligence. All of these items are coterminous, generally speaking, with our due diligence period. So while they've got 30 days to confirm everything to their satisfaction, and believe me, that's adequate time to get it done, they can then turn around and say, look, we found this, we found that, we found this. It doesn't meet our expectations, we're out. But the challenge with that is, if you've got one of those amorphous contracts, well, it's another 15 days, or it's another 30 days, or we got this, or we didn't get that, and you're extending, and you're extending, and you're extending. Never helps the seller. And on top of that, how easy is it for you to start or restart the marketing process?
Okay, so is it safe to say that if we are representing a buyer, we want to use the other one, and if we're representing the seller, we want to use your contract?
Perish the thought. I would never do anything like that.
Quick question on the survey. It says provided by seller.
In this case, the seller actually had the survey, and as part of the due diligence material, guess what I hand them?
The survey.
Sign here.
But I mean, this is just that in that case,
Yeah.
or the buyer will still, as per the lender,
The
will
buyer could require a survey. Well,
Okay.
you know, how about if it's an all-cash deal? What's the buyer have to, really? What's the buyer have to do? Does the buyer have to have a survey?
No,
Does the buyer have to have title insurance?
no.
Buyer even have to have insurance? What's the buyer have to have?
Money.
Cash. That's it, right? So don't get stuck on what the buyer has to have. Now, as a prudent buyer, would you want title insurance? You bet. You bet. You wouldn't want a dead guy from Puerto Rico showing up and claiming half of your property, would you? And can that happen?
Or coming back from Yemen.
You bet. Could happen. Listen, I was involved in a case as an expert witness, and I gave a broker's opinion of value to the court on a piece of property over in Pembroke Park. The guy was from Jamaica. He had like 8 kids in Jamaica, got divorced, moved to the United, bought a little teeny, nasty strip center. I mean, just horrible over in Pembroke Park. It's like 8,000 square foot strip center, right? Worth $400,000. And literally, I went to court because the estate was being challenged by the kids from Jamaica who thought they should get part of this multi-million-dollar property as their inheritance, even though he was divorced and, you know, they were in Jamaica. And so I go to court, and I'm sitting there, and the judge goes, so you priced this thing at like $400,000. How do you feel about the pricing? And I said, if anybody were to write a check for $400,000, Your Honor, my recommendation is sell it to them immediately before they come out from underneath the ether, because this is probably the best offer they'll ever get on that property. He goes, why? I said, well, basically the termites are interlocking their little hands holding the building together at this point. And when that stops, you know, chances are they'll. He goes, so you don't think it's worth any more? I said, I don't think it's worth anywhere near the $400,000 they've got at this point. So I would say let's sell it real quickly before the buyer wises up. And then there's like all these people from Jamaica arranged thinking that this is like a $4 million shopping center. And, you know, he's like, well, it looks like you're all getting something ridiculous. You're all getting like $2,273 a piece. Done. But I mean, it was a nasty little shopping center. You even know who I did that for. I'm not sure. I don't believe so. Oh yes, it's all in a Dropbox.
Where is it under?
Well, under what?
I think it's called something clever like chronology letter.
No.
By the way,
no,
did you
that's what I'm
delete
looking.
Did you deleted the other listing?
You're looking too,
listing
right?
agreement?
Yeah, I'm looking
Remember I
too.
told
Yeah.
you there were two?
The problem. Yeah, I got rid of it. Yep.
Out?
Yep. Now, guys, here's something else that I just remembered and has come to light recently. In my proprietary purchase and sales agreement, I don't know how this happened or when it happened, this section requiring notices, that's what this is right now on the screen, somehow disappeared. So I had to put it back in. But here is literally the notice block. And I want you to take, you know, notice, if you will, of this. Who are we conveying all of this information to? Yeah, well, first off, we're conveying it directly to the buyer, right? We're conveying it to the seller. The seller's attorney, the buyer's attorney, the seller's agent, the buyer's agent, and if there's one involved, the title company. Get it? So we're letting everybody involved in the transaction know what? Yeah, where we're at, what we're doing, and in fact, it doesn't say it here, but like, for example, if it says, you know, the initial deposit's due on January 19th, 2015, I'll put in here due from, you know, XY buyer to be tendered at or with XYZ escrow company, and I'll put that information in there. And then guess what I do? On January the 19th, I'll call up Danny and say, hey, Danny, did you get that deposit? Great, do me a favor. Send me an escrow letter. Or if I'm working with another broker on the other side, I'll call up and say, hey, wait, did you get that deposit? Send me the escrow letter. All right? Now, to head Miguel off at the pass, does that necessarily mean that you got the escrow deposit? For the first time in like 30 years, 2 years ago, I had a title company send me an escrow letter stating they had a deposit when in fact they did not. Okay, but here's the point. If you don't follow up on, you as an agent are guilty of what? Culpable negligence. What's that mean? Well, culpable negligence, the plain English definition of it is stupidity. You're stupid. That's not so bad. You're stupid. Call up, ask for the escrow letter. If you don't and you presume that the escrow is in, you've got problems. You didn't fulfill the object of your employment. Get it? So you want to make sure it's there. When do you get the escrow deposit? Either with the agreement or within 3 days of the agreement. If you don't get an escrow deposit, what don't you have? You don't have an agreement, right? And unless and until that deposit's tendered, what do you do? Yep. And unless and until the owner says, don't sell my property anymore, what do you do? Keep selling their property.
In here, you don't need any authorization from the first buyer, from the person who has the contract with, to continue to offer the property for more backups.
Why? It's not their property. Unless and until they close, it's not their property, is
So
it?
you can continue to market.
Who are you working for? If the owner says to you, we're under contract, stop. What do? You stop. Now, are you going to rely on that?